Hello, and thank you for joining us for today's presentation, CTA Essentials, Overview and Preparing for Compliance, presented by Seyfarth Marcum. All participants are in listen-only mode. You're encouraged to submit questions throughout the program using the Q&A feature on WebEx. However, if your question is not answered, our presenters will receive all questions following the program and will follow up with you directly in the coming days. The program will also be recorded, and a video will be made available to all participants, along with the slide deck that you will see today. With that, I'll turn it over to Doug Farrington of Marcum.
Thank you very much, Andy, and good afternoon, everybody. As Andy said, my name is Doug Farrington, and I am the managing partner of the Boston office of Marcum LLP. I head up in addition to that role of office managing partner, I head up the tax practice for the northern part of our New England region, which includes offices in Providence, Boston, Merrimack, New Hampshire, and Portland, Maine. Serving clients in a variety of industries, including financial services, professional services, healthcare, not-for-profit, and a few others. In my role serving clients in those industries, we strive to keep clients abreast of the various filing requirements that they face. One of these filing requirements has arisen this year as a result of this release of the Corporate Transparency Act. As we at Marcum contemplated how we can help our clients in this area, we quickly came to the realization that understanding and interpreting these rules required legal expertise. As a result, we're extremely pleased today to partner with the folks from Seyfarth on this webinar so that we can all learn from their experience and expertise. It is therefore my pleasure to introduce our panel of folks from Seyfarth. Lou DeFranzo is a partner at Seyfarth Shaw and is the lead of the firm's Boston office corporate department. Lou regularly advises clients on a broad range of transactions, including complex financing, raising capital, navigating corporate governance matters, and more. Lou has been assisting clients in navigating Corporate Transparency Act through his role as outside general counsel to many private companies. Michael Herbst is a partner in the Seattle office of Seyfarth Shaw and is a member of the firm's Corporate Transparency Act task force. Michael counsels privately held businesses in complex corporate and commercial transactions, including corporate formations, mergers, acquisitions, spin-offs, recapitalizations, private placements, and dispositions. He has participated in several presentations and publications related to this topic and what it means for companies. Shamim Mohandesi is an associate in the Seattle office of Seyfarth Shaw and is also a member of the firm's Corporate Transparency Act task force. Shamim advises emerging growth and lower middle market companies on debt and equity financings, mergers and acquisitions, joint ventures, and managing the transition from closely held businesses to high growth, investor-backed market leaders. In addition, Shamim advises institutional investors, including public and private pension funds, universities, family offices, sovereign wealth funds, and various alternative investments. I'm really excited and interested to hear what these folks have to say about this very interesting and important topic. And with that, I will turn it over to Lou.
Lou, you are on mute.
Thank you, Doug. Good afternoon, everybody. Doug, thank you for that very nice and gracious intro. We are pleased to participate today and make this presentation to all of you and to partner with Marcum to bring you some information about the Corporate Transparency Act. So what is the Corporate Transparency Act? I know it's caused a lot of consternation among my client base and a lot of the clients asking, what does it mean for them? So we start by saying looking at what is the Corporate Transparency Act, and it is a federal legislation that became effective January 1 of this year. The act is legislation that's aimed to protect the United States financial system, essentially from financial crimes, money laundering, terrorism, and shell companies moving money essentially without knowing who the real players are. And what it's aimed to do is to give the government insight as to who's controlling the movement of money, and it requires certain disclosures. So the policy of this federal legislation really is aimed at bringing the U.S. up to date with much of the developed world by mandating disclosure of information in regards to private entities. It's going to require certain businesses to file information of their beneficial ownership, which are all loaded terms, by the way, and you'll hear more about them, or we'll learn about them in this presentation. But it's going to require those businesses that the legislation and the act applies to put certain information on record affirmatively with the Financial Crimes Enforcement Network, or what we'll refer to as FinCEN. And FinCEN is going to essentially create and maintain a database of beneficial ownership information for reporting companies that will be able to be used to police essentially the movement of money among entities that otherwise the government really has no insight or transparency as to who's controlling the flow of those funds. So that should give you a general idea of what the legislation that we're talking about is. And we're going to try to cover, next slide, please, exactly, who is impacted, who will be a reporting company under the legislation. What are the requirements of your reporting if in fact you are deemed to be a reporting company that's covered by the act? What the timeframes are for you to get compliant and to provide the information to FinCEN, what's required in your disclosures, and what FinCEN can do with that information once you provide it to the government. And we're going to also cover what we believe to be some of the important, what we'll call next steps for each of you to think about if in fact you need to comply with the CTA. So why don't we jump into what are the actual filings that are required?
Hi all, thank you, Lou. Thank you, Doug. I think, importantly, first we begin with, are you impacted by the CTA? And so, we look first in the CTA analysis to determine if a particular entity or party, is a reporting company under the CTA, which would be required to provide the beneficial owner information that is required under the CTA. And we take the view that you can and should start from the premise that you or your clients are impacted. Unless covered by an exemption, the CTA requires corporations, limited liability companies, limited partnerships, statutory trusts, and any other entity created by the filing of a document with the Secretary of State of any state or similar office to disclose information regarding their beneficial owners and company applicants. In the last number of months, FinCEN has produced and continues to produce ongoing guidance, and often in the form of FAQs that are updated on a kind of monthly-ish basis. And they have most recently disclosed that, or updated, clarified that, entities formed under non-state jurisdictions are also subject to the CTA. So, for example, an entity formed under, a tribal legal regime would be obligated to disclose its beneficial ownership information and company applicants. Sole proprietorships, general partnerships, and common law trusts are not covered. Those are entities which are generally formed without the filing of a certificate of formation or a certificate of incorporation or other similar document, certificate issued by a state or other kind of jurisdictional entity. Interestingly, at the time that, in the time leading up to the onset of the CTA and the beginning of the clock, so to speak, on filing requirements, FinCEN estimated that there were over 32 million entities that were covered by the CTA. I think we can move forward to the next slide. As we mentioned, we start from the premise that everybody is subject to the CTA's reporting obligations, and then look for exemptions, if appropriate, to that obligation. Under the CTA, there are 23 exemptions that are that generally align with types of entities where through another reporting regime, beneficial ownership information may already be known. I won't go through an exercise of recounting all of these, but by way of example, if you're working with a registered investment advisor, their ownership information may be disclosed either through FINRA or the SEC or another regulatory agency. Similarly, if it's a public utility, it will have reporting obligations through a utility commission or the like. Broker dealers are covered by FINRA, and so on and so forth. So oftentimes, we're kind of from a thematic standpoint, you may want to think, if this is an entity that has a reporting obligation outside of the CTA, let's look to see if under the CTA reporting is exempt. Importantly, there's a large operating company exemption, which covers any entity that employs more than 20 full-time employees in the U.S., has an operating presence at a physical office in the U.S., has filed federal income tax or information returns in the U.S. for the previous year, demonstrating more than $5 million in gross receipts, excluding gross receipts or sales from sources outside of the U.S. Often tax-exempt entities are exempt from CTA reporting, and certain subsidiaries of exempt entities are exempt from reporting. As we've learned in our practice, the upper level exemption is generally the easy one. When we start looking down through a corporate org chart and we see JV entities, which maybe have one exempt parent, but another non-exempt parent, that subsidiary entity ends up being a reporting company. And so, the single or dual layer client is really the most straightforward to do the analysis for. It's, as the corporate org chart starts to expand, that we find more and more edge cases. Other things that have popped up, with respect to large operating companies, whether a lack of a physical address in the U.S. would basically void the exemption, and the like. And then, as a rule of thumb, when covering CTA matters or thinking about CTA matters, the clock that everybody should be considering, kind of in the back of their mind, subject to some exceptions that we're going to talk about in the next slide, is 30 days. So when something changes in a business that would require it to report, there's generally 30 days to make a filing. Next slide, please.
Shameen, before we jump to the next slide, if I may, just to kind of put a fine point on this portion of the presentation and to demystify the Corporate Transparency Act, I think if I heard you correctly, what you're saying is our position is when you're analyzing this, you should come at it from an angle of the Corporate Transparency Act applies to me and I need to figure out how to comply unless I fit within one of the exemptions. So the initial threshold inquiry is to look at your org chart, to look at each of the entities and figure out whether or not you fit within these exemptions. You may need to get some counsel around that, but the two most obvious ones or the most frequent ones that I think people will look at for middle market companies will be if you're a regulated entity and you went through those, or if you're within the large operating company exemption, correct?
That's correct. And it's very important to run that analysis at, kind of every level of the corporate org chart, because again, while your top co may be exempt from reporting, you may have, an entity somewhere down in the org chart that's a JV with another party, which is not exempt. And so, much of the work that we're doing today is with, kind of more complicated org charts where we feel that there are some exemptions throughout the org chart, but not, they don't cover the entire org chart, so to speak.
Right. I think that has been one of our experiences in advising clients, is going through the entire org chart and making sure that you do the analysis for each statutory entity that potentially could be eligible. You need to find an exemption for it. And then I would just put a finer point on the large operating company exemption, because it is a three-pronged test, and it's not that you fit one of them. You have to fit all three of those characteristics. You've got to have a location, a domestic location, a physical office here, and you have to have reported in your last tax return more than $5 million in gross receipts, and you need to have more than 20 full-time employees, not part-time employees, not independent contractors. They need to be on payroll as full-time employees. So one of the areas that we've also spent some time in helping our clients is to make sure and inspect whether or not they actually satisfy each of those prongs of that exemption.
Great. So we're moving now into the required filings, and I think it's important to keep in mind that the filing timelines kind of exist in three permutations. They exist for entities in existence as of December 31, 2023, and then entities coming into existence in this calendar year. So as it relates to companies in existence on December 31 of 2023, they would need to file beneficial ownership information before the end of this year, December 31, 2024. And as I mentioned in an earlier slide, this requirement covers something like 32 million entities by FinCEN's estimation. And so we have been, in kind of active communication with our clients about those entities, since really before the beginning of 2020, well before the beginning of 2024. But that's the bulk of entities which need to be brought into compliance, as opposed to entities formed after January 1st of 2024, where they arguably part of the workflow will be some kind of CTA filing. So for entities formed after December 31 of 2024 and before January 1 of 2025, those entities have 90 days from formation to file company applicant information and beneficial ownership information. And we'll cover company applicant information in a bit more detail. For entities formed on or after January 1 of 2025, the timeline is reduced to 30 days from formation to submit company applicant information and beneficial ownership information to FinCEN. Filing of CTA information is really done in two ways, arguably. The most common use case will be to go to FinCEN's website and submit this information directly. The second use case, and perhaps it's not fair to say it would be kind of most common, but it's to use a third-party filing system to submit that information to FinCEN. So a number of registered agent services and filing services have brought online services to submit that information on behalf of reporting companies. Certain entities or services that are in the cap table management space have automated tools to report that information. But whether it's through a third-party service or directly through FinCEN, these are the timelines that apply. And then, importantly, any update to filing information or to reporting information has to be filed within 30 days after the event that would cause the change in reporting information. So, for example, I routinely work with kind of companies that are going through capital formation events. In connection with the capital formation event, beneficial ownership information may change, and so we advise clients that 30 days post-closing is your timeline to update that reporting information. So 30 days is kind of that key number that you want to keep in mind. Next slide, please. So as we mentioned, there is this category of information that needs to be provided to FinCEN, which is the company applicant information. And the company applicant is defined as the individual or individuals who files the document that creates the company, as well as any individual primarily responsible for directing or controlling filing. So we think of this to be, in our case, for example, attorneys may be company applicants, paralegals may be company applicants, a third-party service that forms an entity on behalf of you when you make a request may be a company applicant. It's actually a fairly broad-ranging definition. There are some exclusions to the definition of company applicant. So, for example, there has been guidance that says that the courier who delivers the document that forms the entity is not a company applicant. But a lot of other people may be involved in the process of filing that document, which would be. Generally, there can be up to 2 company applicants on a given filing. And if there's, in the case of a law firm, for example, or for those of you who form entities, if there's a senior and a junior person who are involved in preparing the documents forming an entity, it will likely be both of those individuals. Although if there's perhaps more than one junior person, there may be a bit more analysis to be done there. There are some kind of varied positions on this front. It is becoming the case that FinCEN is producing more and more guidance, clarifying their expectations with respect to company applicants. But for those of you who are in the business of forming entities, it is possible that you will be a company applicant. Next slide, please. So the company applicant information that is required to be provided is fairly simple. It's your full legal name, it's your date of birth, a current address, a unique identification number assigned by an issuing jurisdiction, so this may be your passport number or your driver's license number, plus a copy of the document which the ID was taken from, so a copy of your passport or your driver's license. Next page. And the personal information of the company applicant must be included in each applicable filing. However, for those of you who may be a bit uncomfortable with producing this information to a third party, again, so for example, I may work with my paralegal here to produce an entity, and I need to then provide the formed entity with my company applicant information so that they can make a filing with FinCEN as appropriate. But I may not be entirely keen to give away my home address information, for example. And so in order to address that, every individual who may be a company applicant can provide their company applicant information to FinCEN directly and receive a FinCEN ID or identifier, which is a kind of a single unique identifier that takes the place of your company applicant information. And so in lieu of providing a address, copy of my passport, driver's license, name and birthday, I can simply provide the reporting company with my FinCEN identifier, and they can use that identifier to give FinCEN the name of their company applicant or the identification information of their company applicant in lieu of specific, personal information.
And Shamim, if I may, we're encouraging our clients to actually undertake this process to get the FinCEN ID from FinCEN. It really does streamline things for everybody. It's going to save time for our clients. And in fact, as attorneys, most of us have applied to get our own FinCEN ID number. It is quite painless. It is very easy to do on the FinCEN website. You just need to provide your name, your date of birth, your residence, and you need to give them some sort of an ID number, either a passport number, a state driver's license, and an image of an ID document like a state driver's license. And once you do that, it instantaneously assigns a FinCEN ID number to you that is yours in specific, like your social security number, except this one is kept by FinCEN. And that number can be used for any of the reports where you are a person that's included in the beneficial ownership. So this is a very slick way, an easy way to not have to duplicate pulling together all of your pertinent information. It does put the burden on the person who obtains a FinCEN ID to keep that information up to date, and we'll get into that a little bit later on in the presentation.
Right. So I'm Michael Herbst, and I'm a partner in the Seattle office. And I'll be walking people through the next few slides. So far, we've talked about what a reporting company is and what the exemptions may be and when to file. So I'm going to talk here on this slide about what exactly is being reported, and what's being reported is BOI, or beneficial ownership information. And the BOI that's being reported is reported on an initial report, and there's BOI that relates to the company, and then there's BOI that is being reported as to the beneficial owners. So looking at the left hand of the slide, the BOI for the company's full legal name, any trade names or DBAs the company uses, the company's business address in the U.S., the jurisdiction in which the entity was formed. So charter would be filed with a state, Secretary of State in most cases, but it could be a tribal entity, or it could be an entity formed in a foreign jurisdiction and just doing business in the U.S. through a branch office. And then finally, the taxpayer ID, which in most cases is going to be the employer ID number. As Shamim said, that's simple information, and it is simple information. It's very straightforward. So looking at the right-hand side of the slide then, the reporting company must also file information, BOI, with respect to its beneficial owners. And that information is the full legal name, the date of birth of the individual, and these are all individuals. We're not talking about entities being reported here. These are individuals. The residential address of the beneficial owner, not the business address, not a PO box, it's the residential address. And as was the case for company applicants, a identification number taken from an ID document supplied by the beneficial owner. In many cases, that's a passport or a driver's license or some other kind of state-issued identification document, plus an image of the document from which the ID number was taken. Many of these documents have pictures, so just understand that each beneficial owner's image, in most cases, is going to be part of the the Treasury Department's database of BOI. So notice that there's no social security number that's being required here. It's limited to those items. If any of this information changes, as Shami mentioned, an update needs to be filed within 30 calendar days. And that's 30 calendar days of the date of the change. It's not 30 days after the reporting company first learned that the change had occurred. It's 30 days after the change has occurred. And so I think what that tells you, and we'll get into this later, is that companies need to create some processes, procedures to gather up BOI and make sure the BOI is always current. If there's a change in BOI, the company needs to be informed so it can make the appropriate update report to the Treasury Department. So what happens to all of this information? This is a, don't move to the next slide yet, please. Yeah, thanks. So this is information that's being gathered, as Lou said, for law enforcement purposes. And so it shouldn't be a surprise to anybody that FinCEN is authorized by the statute to share this information. It can share the information with any federal agency that's involved in national security, intelligence, or law enforcement, any federal agency. It can share the information with any state law enforcement agency, but it has to be pursuant to a court authorization. FinCEN can also share BOI with foreign law enforcement agencies and foreign courts that are engaged in law enforcement functions upon request from a federal agency on behalf of that foreign law enforcement agency. FinCEN can share BOI with financial institutions, but only with the consent of the reporting company. And finally, BOI can be shared with other Treasury Department employees in the course of their official duties. And recall that the Treasury Department includes the IRS, so this information can be shared for tax enforcement purposes. How long could this information be kept by FinCEN? The statute requires the information be retained, BOI be retained for at least 5 years after the company's existence terminates. That's at least, so potentially FinCEN could keep this information forever, and they may very well do so. So let's move to the next slide, please.
Michael, as we move to the next slide, before we jump into these loaded terms that we referenced earlier about who are beneficial owners, I just think it would be good to take stock. So essentially, the FinCEN has a mechanism under this legislation for companies to self-report essentially ownership and control over money on entities that are statutory entities that they heretofore have not had any real ability to gather that information or monitor it or police. So there's no central repository for this self-reported information. And as Shamim covered, that information is phased in. Entities that are formed prior to the enactment of the legislation of this year or the effective date of the legislation have a full year to make these reportings and to get through this process. But if you're forming an entity this year, you have 90 days, and that's going to be curtailed to 30 days starting next year. So you can see that the government is trying to phase this in to create a database so that it can enforce and share information with law enforcement and other federal agencies and maybe some state agencies on subpoena. And I just think it would be important to also note that there are penalties, both civil and criminal penalties, that can be imposed by the government if, in fact, an entity does not comply timely with the requirements of the act. And I don't say that to put fear into anybody. I don't think that the government necessarily is going to be trying to come out and try to find people that don't get with it quickly enough, but they do have that out there as an enforcement mechanism. And I do think that people need to take this seriously. So I just wanted to recap that and kind of tie it back to what I said at the outset, which is the policy of the legislation to create this database of self-reported information that needs to be maintained by the reporters giving information to FinCEN. The information can and probably will be shared for these purposes. And now we're going to turn to who is it in those reporting companies, if you're not exempt and you must report, who is it in those companies that needs to provide that beneficial ownership information?
Yeah, I think that's a good overview, Lou, and just as you know, from a high level, looking at this from a policy point of view, there's been a steady progression of information gathering. Initially, it was financial institutions being asked to collect information about beneficial owners of companies opening bank accounts. Right, that was the first step. Now we have Corporate Transparency Act, which is ownership of entities, and eventually, I'm fairly sure we'll get to ownership of real estate and reporting the ultimate beneficial owners of real estate. That's not here. That's not in the Corporate Transparency Act, but I think it's kind of the next logical step that we can expect in the both U.S. Treasury Department and internationally, the desire to combat tax evasion and money laundering. But to turn to the next slide, here we're going to discuss who is a beneficial owner. We've been talking about beneficial owners now for quite a while, without really telling you, who that is. And so there's really two kinds of beneficial owners. There are the people who own ownership interests in the reporting company. And then there's the people who exercise control, substantial control over the company. And both of those are within the definition of beneficial owner. And when I say beneficial owner, I mean both categories. But just understand that somebody who owns substantial control and is therefore a beneficial owner may actually own no ownership interest, right? They may actually own a zero ownership interest in the entity, but they're nevertheless beneficial owners because of substantial control. So taking those one after the other, a beneficial owner who exercises substantial control. This includes senior officers, and there's a definition of senior officer in the regulation, and it includes the CEO, the CFO, the chief operating officer, the chief legal officer or general counsel. There's some positions that are named, but there's also individuals who will exercise substantial control on a functional basis as opposed to because of their title. And the regulation says that anyone who directs, determines, or has substantial influence over important decisions made by the reporting company is exercising substantial control. Well, what is substantial influence? And what are important decisions? I mean, it's really in the eye of the beholder. And so I think what I want to emphasize here is there are some people who are obviously going to be beneficial owners because they exercise substantial control, the COO, the CEO. And there's people who may or may not, and it's going to be a judgment call as to whether you decide to report them as beneficial owners. Is the director of operations for the Middle East and North Africa a person who is exercising substantial influence over important decisions? Maybe, maybe not. It depends on the company, perhaps. And also, I'd like to emphasize that we're not only talking about employees here. You might have an outsourced CFO, for example. They're not an employee, but they're exercising substantial control, and so they would be reportable as a beneficial owner. I would say that board members, in almost every case, are going to be beneficial owners, whether or not they actually own ownership interests. And that's because, if you think about it, a board member is somebody who has power to elect and remove the senior officers of the company. And that just seems like an exercise of substantial control to me. So
Michael,
that's,
Michael, fair to say that this is, similar to the threshold inquiry of finding out whether you are a reporting company and fall within an exemption, that this is really one of the most fertile areas for, interpretation and getting some guidance. And hopefully, FinCEN will issue some guidelines around this. I mean, the black letter part about do you own 25% or more of the company is pretty easy to answer, right? We can all do that looking at a cap table for the entity. But when you start to talk about exerting substantial control, as you've noted, I mean, that can be a pretty amorphous standard, subjective standards certainly, as to who qualifies as exerting substantial control. And our advice, at least in my experience, has been to be fairly conservative, to loop in, the finance arm of the company, people that have control over bank accounts, people that move money, and again, to make it easy, to have them get their FinCEN ID and be able to report in that manner, so that the beneficial ownership information of those persons who have substantial control or may be deemed as having substantial control are included in the reporting.
yeah. And you can err on the side of caution, Lou, and say, well, maybe this person is, or maybe this person isn't. So we're going to report them. And that's going to work in some cases, but for some companies, I think they'll just, that's just not their thing.
What do we foresee, Michael and Shamim, if anything, about getting some further guidance or rulings from FinCEN and the government on these standards? Do we anticipate anything coming out, or do we expect this is going to be maybe determined through litigation, possibly, or what is the outlook for these standards?
Well, I think, all of the above on some level. The FinCEN is actively in the process of clarifying its guidance and adding to its guidance, kind of on a 30 to 60 day cycle. And this would be a good place for us to plug. Seyfarth has, as was mentioned earlier, a task force that is focused on CTA compliance, and we generate an update usually about 48 hours or so after FinCEN updates its guidance, to keep clients and those who are just interested apprised of kind of these changes or further clarifications. They come in groupings of about 10, where they'll say, we've received a number of inquiries on this subject. Here's the kind of the best thinking. Most recently, there was a question about, what if beneficial ownership information changes as a result of litigation? And the guidance was, you have 30 days from a court order, essentially, to update your beneficial ownership information, notwithstanding, the ability to appeal. So there's kind of a rolling base of knowledge that's kind of updating regularly.
Yeah, I agree with that. I think FAQs are going to be coming out, and sometimes they're useful and sometimes they're not. I saw an FAQ dealing with our board members always exercising, our board members always beneficial owners, and the answer was maybe. So, I mean, it's coming out, and whether the guidance is useful or not is I guess we'll see. The other thing that I've done is I've actually emailed FinCEN and asked specific questions, and I got an answer in 24 hours. So that's also something that could be done. But just to move things along, the second prong here is ownership of an ownership interest. So in many cases, this is going to be really easy. A lot of companies only have one class of ownership interest, and you look at the stock ledger and you do your math and you figure out who owns 25% or more. But in many cases, it's not going to be that clear cut, right? So a lot of companies have multiple classes of stock or multiple classes of shares, and the shares convertible into another class based on some formula that that you know that isn't easily ascertainable as to how much is going to be owned after conversion. And then ownership interest is also defined to include capital or profits interests, in the context of LLCs and entities, taxes, partnerships. And a lot of LLCs and partnerships distribute their profits or their net income under a waterfall. And if you're fairly low down on the waterfall, you have no idea, what your profit interest is actually going to be, because it depends on the economic performance of the entity and how much is absorbed by the waterfall layers above you. So in some cases, it's going to be clear cut. In other cases, it's not going to be clear cut at all. And also note that we're talking about warrants and options before they're exercised are ownership interests for the purpose of calculating whether somebody owns 25% or more. And that's calculated as if the option or the warrant has been converted, but not on a fully diluted basis.
Another example where we've had this pop up, is in a charter where there's a minority of shareholders who would be below the 25% threshold, but because of some enhanced voting rights, would have kind of an effective control that was above the 25%, which was kind of interesting. But not something we see that often anymore.
Yeah. So I think the more complex the capital structure is, the less clear cut the 25% threshold is actually going to be. If you're a lender and you have loan documents with covenants that give you, negative rights or consent rights or approval rights, the regulations say that doesn't count as substantial control, and so you would not be reportable if you're a lender, unless, of course, you're lending under a convertible note and you can convert to equity, in which case you would potentially be a beneficial owner. Some entities don't have owners at all, so a lot of all nonprofits have no ownership. There must be tens of thousands of condo association corporations and homeowners association corporations out there, but no owners. There's no exemption for those unless they qualify for 501c, a tax exemption. So all of these kind of mom and pop HOA associations, people are going to have to be reporting, at least with respect to those exercising substantial control. Those will be the beneficial owners of those kinds of entities. I think we can move to the next slide. So as Lou said, there's civil and criminal penalties, but it's for willful failure to report or willfully providing false or fraudulent BOI. And I think we and everyone is interpreting that to mean if you make a really good faith effort to comply and there's some kind of footfall, you're not going to be thrown in jail. But I think it also tells us that that to avoid a claim that you willfully failed, you really need to be making an effort to comply, and you need to be documenting your efforts to comply through things like seeking outside advice, adopting policies, conducting training. We'll talk more about that in the next slides. But willful failure is an important concept to remember in the context of CTA. Civil penalties up to $10,000. That's inflation adjusted, so it's actually more now. And criminal penalties for willful failure up to 2 years in jail. Next slide.
So we've kind of covered an overview, if you will, very high level of what the CTA is, and what the general outline of the legislation means to you. And with that, we kind of shift to, okay, what do I need to do as the next part of this, based on that knowledge of what is the CTA. And so we're going to talk about the following. There are some preliminary matters that a company should begin to do internally to make sure that they are compliant once they determine that they're a reporting company and they don't fall within one of the exemptions. So you really need to identify the individuals in your company that are going to essentially be your compliance office, that are going to dig in, understand the CTA, work with your counsel, in-house or outside counsel, to make sure that you're in compliance and follow the developments. You're probably going to want to adopt a policy within the company. And that may be, for example, you may want your senior officers and folks in the financial area, and maybe your in-house counsel, if you have that function, you might want them to get a FinCEN ID number for themselves and supply it to you, and put the onus on them in your policy to keep that information up to date between themselves and FinCEN. You may want to develop some training. I think those products are going to be developed over time. And you're going to need to get your org chart together and try to really dig into each of the entities. As Michael mentioned early on in the presentation, it might be simple when you have a single entity or a parent subsidiary organizational structure, but if you start to have an organizational structure where you have either up the organizational chart and you're responsible, or you're kind of the sponsor, and you've got other partners that are in your entities that are putting money into your company, those entities are going to need to do their own analysis. And then below the primary operating entity, any subsidiaries and any joint ventures and any minority owned subsidiaries that you have, you're going to need to do that type of analysis as well within your own organizational structure. And you're just going to need to work through the CTA to determine whether your entities are a reporting company and have obligations, and consult with your attorneys as needed, and FinCEN to determine if you are eligible for any exemption and can avoid having to do the reporting. Once you determine that you do have to report, we can go to the next slide, then you're going to need to build some mechanisms in those policies about collecting the reporting information, and you're going to make those decisions about who are the individuals that you'll be providing beneficial ownership information about, the owners that fit the criteria as needing to be included in those reports, as well as the persons exerting control within the company. Again, we talked about getting the FinCEN ID number and for people that you're going to need to include in those reports. And you're going to have some ongoing obligations here that you're going to need to probably have policies and procedures about to be compliant with CTA going forward.
And Lou, I'm just going to jump in here and point out that collecting the BOI from the beneficial owners. I mean, once you've decided you're a reporting company and you've figured out who the beneficial owners are, right? Which is going to be a mix of the control people and the ownership people, right? Then you actually have to go out and get the information, right? Or they've got to get FinCEN identifiers. But assuming they haven't gotten their own FinCEN identifiers, you're going to have to go to every beneficial owner and say, please give me the following information. And I'm sure many beneficial owners are going to be cooperative, but there are almost certainly going to be some beneficial owners who are uncooperative, and you're going to have to figure out how to get that information from them. And there's going to be beneficial owners who, while they're not uncooperative, they're on a safari in Africa all the time, or they're being dilatory in some way. I need to hear from my CPA before I can give you that information, whatever. And so there's no end to excuses, of course. And so as a company, you need to start early, because you need to build in some period of time to actually extract this information from potentially uncooperative or dilatory beneficial owners.
Yeah, Shamim, do you want to pick up on some more of the items that companies should be thinking about, what they need to do once they determine that they are a reporting company?
Yeah, I'm happy to. We might be a little bit off on the slide count.
Yeah, we can go. Yeah, we can go to 17 here.
Sorry, I think I've lost my spot here. I apologize.
So I think we're going to the timing of when you determine if you determine that you are covered by the act, that when you need to report. And we did talk about the time frame earlier.
Yeah.
Again, if you were created, before January 1, when the legislation became effective, then you've got the full year to actually get compliant and make the filings.
Yeah,
That's
and
right.
I would just admonish people not to wait until December 31 because everyone's going to wait to December 31 and then the system's going to crash, right? So I think what you need to do is, be very proactive, start early, and get the information in hand so you can file in the summer or in the early fall before things get out of hand.
And I think it's important to note that these filings can be made directly on the FinCEN portal. So, you can Google that, you can get on there and take a look to see what in fact the format is, or you can get some guidance and advice around it from counsel or somebody that's gone through it. But it's once you do pull the information together, it's relatively easy to report it mechanically.
Yeah.
That's right.
And this goes back to, I think earlier we were talking about adopt a policy. I mean, I think it's really important to create the internal discipline in your company to actually comply with this law, to have a thoughtful policy, and by all means make sure that somebody has been identified as responsible. Because my experience is if everyone's responsible, then no one's responsible. So somebody should be absolutely tasked with compliance with the CTA. So that the line of responsibility and reporting is really clear.
Yeah, we can go to the next slide.
I think we've covered everything here as well.
Yeah, these are some of the considerations that you need to be thinking about, in being compliant. So yeah, we can move on to some of our other concerns aside from reporting that are best practices.
So here we can talk a little bit about. So we've talked about having somebody who's your point person on CTA matters generally, but there's some kind of downstream things that I think are maybe less commonly discussed that need to be contemplated. So for example, you're collecting, depending on your role, you may be responsible for collecting this information for reporting purposes. This is sensitive information. So being mindful about, whether this information comes through a secure portal, like a client management portal, versus through email is important and something that should not be given short shrift. Whether, there's some privacy laws or other kind of data security regime that would impact the data that you're collecting for reporting purposes, and then also disposing of the data in kind of a timely and secure manner. Working through all of your governance and transaction documents for CTA related provisions. One place where we're thinking about this a lot in our practice is in shareholders agreements and subscription agreements and questionnaires, making sure that we're getting the information for clients so that they are in a position to report the information as is necessary. In employment agreements, whether there's some determination or establishment of whether this person is a control person or not is something that I think it merits review. And then in indemnification agreements around directors and officers, ensuring that they're adequately protected and that they're aware of their obligations or the company's obligations under the CTA. And then, lastly, and this is kind of just a general hygiene matter, dissolving inactive entities that, are hanging around and don't really have a purpose anymore, kind of the liabilities attached to that entity may have expired and, now it's hanging out there and requires reporting. And so, kind of being mindful all through the administrative life cycle that, the CTA is part of your checklist is going to be a bit of a change in practice, but one that we're, actively working with clients on now.
Yeah, I mean, for example, I've seen it becoming a growing trend. I think where you're going to see this is institutional lenders will catch up to this. You're going to start to see requirements that say things like, the company represents that, it has, complied with the CTA and it's in compliance with the CTA, or it's otherwise determined that it's, not a reporting company they're under. So they're going to make you as a lender make companies represent whether they've done the analysis. They may even go further and ask a company to represent that it's adopted policies to stay compliant with the CTA. So I think, the takeaway at the end of this is that the area, in addition to getting guidance from FinCEN on some of the standards on the beneficial ownership information and who in the company needs to be reported on, I think that in the market, both, in the transactional market, whether it's a loan, whether it's a M&A transaction and it's a target, these are things that are going to be looked at your company, and I think you need to be up to speed as they evolve in the marketplace. Okay,
Before we jump to other questions, and this is something we chatted a little bit as we prepared, but as often happens with legislation like this type of legislation, somebody out there is bound to challenge it, take it to court, and we've seen it happen time and time again. And to your point earlier, Michael, about let's not wait till the last minute here, let's be prepared. I'm just curious if you guys would like to kind of share your take on potential challenges to this legislation and how people should view that and not get caught up necessarily in assuming things are going to happen. I think it might be helpful to share that.
Yeah. Well, we don't have to use our imaginations to see what's happening. It's already happening. There's a lawsuit that was filed in the federal court in Alabama challenging the constitutionality of the legislation. At a high level, the plaintiffs are arguing, National Small Business Administration is the plaintiff, and they're arguing that the law is unconstitutional. It is unconstitutional because the Corporate Transparency Act isn't authorized by the Commerce Clause or by the Taxing Clause of the Constitution. And the federal judge in that case has already issued an injunction against enforcement of the law, but only as to those named plaintiffs, right? So if you're not part of that plaintiff group, the injunction doesn't apply, and you need to comply with the law. The 90-day period for new companies, you've got 90 days, and nothing has changed. And there's also been a lawsuit that was just filed at the end of May in Maine, also challenging in federal court, also challenging the constitutionality of the Corporate Transparency Act. We don't know, how those cases are going to be decided. We don't know when those cases are going to be decided. We don't know, whether Congress would be able to get its act together and make changes to the law to address any constitutional deficiencies. There's a lot we don't know. But what we do know is that you probably should just comply as if, assuming the challenges are not successful. Lou or Shamim, do you have any kind of different take?
I think that, whenever there's new legislation, this is part of the process of determining the scope of the legislation. And it's not surprising that, this plaintiff in Alabama has brought the suit. I think you'll see it happen more frequently. It is part of the process and to be expected. I think it goes right to the nub of what's going on here. I think there's a concern about Big Brother and the government gathering information on entities and where they get the power to do that. But the pressure has been on the United States, frankly, for a while in the developed world, because maybe contrary to what a lot of people understand, the United States was actually one government jurisdiction internationally that there was not a lot of transparency into entities and ownership and control of money. And you've seen the advent of KYC requirements, and the government's ability to monitor and dig for information. I think this is just kind of a natural extension of that, and it's not surprising there's some resistance to it. My guess is that it will get evened out, and there will be some harmonizing of the decisions at the state court level, and Congress ultimately will get its act together. And I think that if I had to guess which way it's going to go down, there is going to be some oversight and some federal database of reporting of who has control over entities and the flow of money. It's just something that's in the brave new world with what's going on and all the money flowing internationally. So our advice has been to get ready to comply and be compliant. If you want to get ready to comply and wait for further guidance, that's certainly on you, but I wouldn't wait until the last minute and count on the fact that these challenges are going to ultimately prevail and that the CTA is going away in all of its elements. I don't think that will be the end result, but we shall see.
I agree.
Okay. Well, if there are any questions, we're happy to take them, and we're happy to answer them after the fact. If anybody has any questions, feel free to reach out. We will be sharing the slide deck with all participants. And if you have any questions, again, you can email us or you can reach out. Our contact information is there. Reach out to Doug. Happy to arrange a time to speak and try to figure out if we can be of any help to you as you try to navigate the Corporate Transparency Act.
Thank you, Luke. Thank you, Doug.
Great.
Take care.
Thank you, everybody.
Thanks.